All right, we are going to get started. Welcome, everybody. My name is Melissa Murphy. And I guess I'm kind of like a bad penny. I'm back. I practiced law here in Gainesville for, I think 35 years or so doing real estate transactions, and then left for a corporate job down in Orlando where I had a blast in Orlando doing that job, but I retired from that job on October 1st. So now I'm back in Gainesville and still involved in the industry. Hence, I am here to talk about this very important rule that we're all going to be dealing with very, very soon. So I'm going to let my fellow panelists introduce themselves. Patty?
We were told we had to use the microphone. Good morning, I guess, good afternoon. I'm Patty Moser. I wear a few hats. I am the broker at Horizon Realty, so I'm having to deal with this from the brokerage side and then also a lot with title services in the title industry about 25 years. And as we work in FLTA. So we've got a few hats in here in the ring.
My name is John Roscoe. I'm also a real estate closing attorney. Today I'm here as counsel for the Gainesville-Alachua County Association of Realtors, joining two great colleagues.
Patty and I are here on behalf of FLTA, who's actually sponsoring this presentation, as you can see from the slideshow. And the Florida Land Title Association is very involved in your industry and making sure that private property rights are protected, that transactions are not overly burdened with unnecessary rules and regulations. We're somewhat more successful with that purpose at the state level than we are at the federal level, hence this rule. But I want to make sure that everybody is aware of FLTA and the very good work that it does. Patty and I serve on the board of FLTA, and we discovered that there is perhaps a gap in the level of knowledge of this new rule when it comes to your side of the industry. And so we're hoping to close that gap today. Now, our approach to this topic today is very high level. Is high level information about the rule, and we want to focus on what it is you need to start paying attention to from the perspective of your involvement in real estate transactions. I am going to do most of the yakking today about the technical requirements of the rule, and then Patty and John are going to chime in to make connections between the rule and what you need to be doing to help your customers. So they're going to help keep me on track with the right focus today. Closing agents and title agents that are in the rule room, you will not leave today knowing everything that you need to know to comply with this rule by any stretch. We're going to do a high level review today and focus in on what brokers and agents need to know. There is going to be time for Q&A at the end. And not suggesting that you have to leave your questions till the very end. If something we say is really confusing to you, raise your hand. You'll need a microphone to ask the question so that our colleagues in Zoom land will know what your question is. And if those of you in Zoom land, if you can't hear me, which would be surprising, but if you can't, just let Susan know, and then I'll start using the microphone. Key dates. This rule goes into effect March 1st. What is required? It requires the reporting of all cash transactions of, sorry about the typo, of residential property in which an entity or a trust is the purchaser. We will delve into more detail as to exactly what that means. Who is responsible? For purposes of today's conversation, the closing agent is legally responsible under this rule to report those transactions that are covered by the rule. So, why do you need to know about this rule? And what is it that you need to know? The purpose of the rule, as represented by the previous slide, anti-money laundering rule, is FinCen, the Financial Crimes Enforcement Network, which is a branch of the Department of Treasury in Washington, believes with all their heart that there is rampant money laundering going on with regard to the purchase of residential property. So bad people who have dirty money are trying to launder that money through purchasing residential properties in an entity that they ultimately own, but they are convinced that that is rampant and they are trying to stop that. And the purpose of this rule is to identify those potential transactions in which that is going on so that law enforcement can be aided in their efforts to stop it. That is the whole purpose behind this rule. So why should you care? We're going to hit on this several times because you want to take good care of your customers. You want to be able to tell them up front that this requirement is likely to apply to their transaction. Prepare them for Roscoe to call them and ask them a whole lot of questions about their entity or request that they fill out information. You want to encourage cooperation with the closing agent between your customer and the closing agent because you want to make sure the transaction goes smoothly. And what's the most important thing? Close on time. And you will look really smart. I am convinced that when you are talking with a buyer or a seller in a transaction in which this is likely to apply, if you tell them about this rule ahead of time and you explain to them that there's going to be information that the closing agent is absolutely going to need, and here's the kind of information, then when the closing agent contacts your customer is going to say, oh yeah, my real estate agent told me about this. I do understand why you're asking me these questions. You're going to look really smart. All right, what transfers have to be reported? And non-financed cash, we're going to go into what that means of residential real estate, where the transferee, the buyer, is an entity or a trust. And here's a key component. There is no dollar threshold. So don't think that, oh, this is just a $15,000, little lot sale. No dollar threshold. And there are some exempt transfers that I'm going to talk about in just a second. We're going to talk in more detail about what non-financed cash means, what residential real estate means, and then exempt transfers. So non-financed cash. That means there is no lender involved in the transaction that has a requirement to comply with anti-money laundering policies promulgated by the federal government. Parents don't count because typically parents don't have anti-money laundering policies that they have to follow. Banks, normal banks, have anti-money laundering policies they have to follow. So parents don't count. Seller financing doesn't count. Generally, the typical seller would not be a bank or an entity or a company with anti-money laundering policy requirements. So seller financing doesn't count. And here's the challenging part. Hard money lenders don't count either. So joint ventures that are formed with people with a lot of liquidity who love loaning money out at higher percentage rates than they can get under other investments, they probably do not have anti-money laundering requirements that they have to comply with. So your typical hard money lender is not going to, if they are participating in this transaction and loaning the buyer money, that is not going to exempt that closing from the reporting requirements of this rule. Exempt transfers. These exemptions probably aren't going to help you a whole lot in your everyday work. Transactions pursuant to a divorce or dissolution, those are exempt. So if in a divorce situation, the wife is obligated to transfer interest in some property to the soon-to-be ex-husband, that transfer is exempt. But that would normally be done, for no consideration or not part of a transaction that you would normally handle. Transactions or transfers associated with someone's death are also exempt. So if I own property, I pass away, and my personal representative, pursuant to my will, conveys property out to my children, that transfer is exempt. Again, not a transaction or transfer that you would normally be involved in. Court supervised transactions or transfers, like foreclosures of any type, are exempt also. And if you're involved in a 1031 exchange, the transfer from the current owner to the qualified intermediary who's going to hold title temporarily, that is exempt. But when the qualified intermediary conveys to the ultimate purchaser, that will be reportable. And then some very narrow situations in which an individual conveys property to their own trust, of which they are the settlor or grantor. A lot of people do that for estate planning purposes. That is exempt. Again, you all don't normally get involved in those things in handling a real estate transaction. So enough about exempt because it's not going to apply very much. All right, now we get into some interesting nuances. What is residential property under this rule? Property on which there's a structure, a building, a house, a small apartment building, a duplex that is suitable for 1 to 4 family occupancy. That's residential property. Vacant land on which the buyer intends to build a structure suitable for 1 to 4 family occupancy is residential property. Intends to build, subjective, not objective. So here's where you can get into some nuances. If your buyer swears up and down, I am not going to build on that residential lot, I'm going to hold it for investment, it's exempt from reporting. So let's talk about the challenges associated with that subjective standard. How does a closing agent or you as an agent involved in the transaction feel comfortable that they're telling the truth, that they are truly not going to build on the property? Any input from the gallery back there?
I assume from a closing agent perspective that we're gonna want some kind of signed certification or affidavit saying I intend to live on the property. But I wanted to bring up some other just
Sure.
things that I think you might run across that I found interesting. We often find people are gonna borrow against some other property and get some kind of a credit line and use that to purchase. So that's still considered cash because they're borrowing from somewhere else. Vacant land, like Melissa said, 1 to 4, but it could be 200 acres. And if they intend to build on it, or if it has a home on it, that is still considered residential property under this rule. So even though it might be zoned agricultural, might have ag exemption, got nothing to do with it. If it has a house on it, it's a single family residence under this rule. So also, mixed use, I think she might have mentioned, so if you have commercial above or commercial below, residential above, it still would fall under. So I think there's just a whole mobile homes. A mobile home, as long as you're selling the land and the mobile home, it would also fall under the rule. So those are just some little nuances that I think, we will face in our industry. And then I'll let John talk about how you might want to cover the closing agent, making sure they're going to intend to live there.
Well, as far as I'm aware, we as closing agents are able to rely on information that is provided to us, unless we know that information to be false. So if I'm sitting there in a closing and I present a certificate that says, hey, you're buying a piece of vacant land in this entity, and I need you to certify that you are not going to build a residential property there. And they go, that's correct, I'll sign it. I'm gonna rely on that.
You are, and you have the right to rely on it under the rule.
That's right. But if the person says, well, I don't want to provide all that information that your 111 fields of questions need to ask. In my case, I'm going to use a third-party vendor to collect that data. So why don't you close your eyes for a minute, wink, wink, nod, nod. I'm going to start construction next month. Well, I'm not going to rely on that.
Right.
And the other thing that's critical for y'all to understand about us as the closing agents is these fines can get to 6-figure numbers.
In jail.
Okay, and jail time. So I can craft an awesome indemnity agreement where someone says, if you screw up this information, you'll pay the fine on my behalf. But I haven't figured out yet how to send someone to jail on my behalf. So if y'all have any clever ideas, many of you have my email or my text number, but that's the major problem we're confronting. And once you get into willful violations of this rule, you're talking about jail time.
Yeah.
And don't blame it.
Yeah, so, I read, local estate planning is not covered, correct?
Yeah, normal estate
In
plan.
normal estate planning, but one thing I did read, was that if a developer is buying a piece of property, it could still be, if it was planned for residential development, they could still fall under the rule.
Correct. Because it doesn't matter that it's vacant now, if they intend to develop it and build homes or condos on it, or townhomes, or a co-op, it would be covered by this rule. Timing doesn't matter, which makes this intends to build a structure standard a little wonky for those of us who are used to very black and white rules. All right, now I'm going to spend time telling you what kind of information, the depth and breadth of the information that has to be collected. And I'm going to run through this pretty fast because you are not expected to memorize this or know this for sure, but I want to give you a sense of the level of detail that is required to be collected by the closing agent and is going to be asked of your customers, your clients, to provide. So what must be reported? Basic transaction information, the closing date, the purchase price, the parties' names, the property, address, or legal description if there's no address. Seller information is required, including information about the beneficial owners of the seller, if applicable. Buyer information, including beneficial ownership information, which will be applicable in the case of a buyer. And recall the purpose of this rule: anti-money laundering by a buyer. So most of the information that has to be collected to comply with this rule focuses on the buyer. That's where the real nitty-gritty comes. And then information about the money, the payments to the settlement agent, to the closing agent. That will probably touch and concern many of you all in this room. So let's get into detail. Seller information for individuals: legal name, date of birth, current residential address, and tax ID number, social security number. Entities: legal name, DBA, current business address, tax ID number. If the seller is a trust, full name of the trust, date of the trust agreement, tax ID number for the trust, and for the trustee of that trust who is going to be signing on behalf of the trust, their legal name, address, and tax ID number. Buyer information: entities and trusts, basic info, legal name, business address, tax ID number. For the beneficial owners of entities and trusts, and I'm going to talk about who those people are in a minute. For each beneficial owner of an entity, which is a corporation, an LLC, a limited partnership, they want the full legal name, date of birth, residential address, citizenship, that's something new, tax ID number. And then someone's going to be signing on behalf of the entity or trust, and FinCen wants to know the capacity in which they are signing. That's not too difficult. All right. Who are beneficial owners? You may.
I want to interrupt for just a second because the three of us are very well aware that we are speaking to realtors and trying to find out what your role is in this. It's going to be very different than Patty and I or any other closing agents that are in the room, okay? But when you look at that list of information, can't you foresee the person that goes, I'm not giving you that information? Absolutely. I mean, it's very foreseeable. So I think you are going to be the front line of communication with this. So not only right up front do you need to say, hey, I see that you're going to be buying in an artificial entity or a trust. Know that Patty and John and whoever else is here that's a closing agent, they're not asking this because of a whim. This is federal law with significant penalties for the closing agent. So please be prepared to provide this information, or otherwise you need to go a different route. Because we're not the bad guys. We don't like this either. But you need to be preparing the customers that you're working with that all of this information is going to have to be provided. And if it's not provided, we're not closing your deal. Because we're not going to have 6-figure fines or go to jail for someone that just wants to wrap themselves in the American flag and say, that ain't right. I don't like it either, guys, but we're merely the messengers, not the creator of the message.
I just want to add that, this is, you can see already, and Melissa hadn't even got through all of the others, but you can see already how much non-public information is here. You got federal ID numbers, you've got, social security numbers, you've got all this stuff. So we just want to make sure most all closing agents, attorneys are all going to have some kind of portal, either their software program where you're going to be able to have your buyer submit the information directly. You all do not want to touch in any way, shape, or form any of that information. You do not want to be the transmitters. And we don't want to piecemeal either. Like, I don't want you to send me an email that so-and-so, this is part of it and part of it. No emails, no text. It has to be in some kind of very secure portal or way of transmitting it, and your email is not it. Okay, so just please realize that you don't want to put yourself in a position of your social security numbers being stolen.
And let me get into who the beneficial owners are, which segues nicely from John's comments about people objecting to having to share this information. Because this information, the information of who are the beneficial owners of a particular entity or of a trust, those are not of public record. So that is information that theoretically people assume will not be revealed, will not be shared, will not be accessible information. Like, who are the beneficiaries of this trust that I have? Who are the individual owners of this LLC that I have formed? Who are the investors with me? That's normally not public information. And so there is the real concern that there is going to be resistance on the part of primarily buyers to provide this information. And John and Patty make a very, very good point that they have to comply. They have no choices as a federal law. And whatever information you can give them ahead of time, so it's not at the last minute, is going to go a long way toward facilitating this closing happening on time. So who are the beneficial owners of an entity? any individual who directly or indirectly owns at least 25%. So it is true that if you're talking about an LLC as a buyer, those people that own 10%, they're not going to have to report their information. It's the people who own at least 25% or have substantial control over the entity. What does substantial control mean? They're a senior officer. They run the place. They have the authority to appoint senior officers. They direct decision making. What does this do? This pulls into the rule nonprofit entities, because nonprofit entities don't have owners. They don't have shareholders. They don't have members. And by this definition of a beneficial owner, then nonprofit entities are also covered by this rule. That is not a loophole for somebody to form a nonprofit corporation under Florida law and then launder money through it. Who are beneficial owners of a trust? The trustee. Any individual other than the trustee who has the authority to say, sell all the trust assets and disperse it to the beneficiary. A beneficiary who is the sole recipient of income from the trust or can demand that the trust give them money. And notice the sole recipient, that indicates one person. The grantor settlor of a revocable trust. So right there, it's like, all right, Patty, you decide whether or not that trust is revocable, something that a title agent does not normally do. Not something that you would normally do. You're not supposed to make that decision. But this is where this law gets a little tricky. But certainly the grantor knows whether their trust is revocable. So they don't care about irrevocable trusts. Now, payment information. For each payment by the buyer or by someone on their behalf, the closing agent is going to want to know the amount or has to report the amount, the method of payment, wire, cashier's check, money order, name of the bank from which the money came, and the account number. That is not something that the closing agent typically receives when their bank is wired money from someone who is sending money on behalf of the buyer, or it's the buyer themselves. That wire verification will say money has been sent to Alachua Title Services. This is the amount. This is the bank it came from. This is the person who sent it, but it doesn't tell Patty or John the account number that it came from, and then the name of the payor, if not the buyer. So, closing agent's going to be calling that person that sent the wire, and it may very well be the buyer, and say, I need your account number at Wells Fargo or at Chase. That's going to put some people on edge. Now,
Give money from a parent.
Give money from a parent. Keep in mind that this only covers transactions in which an entity or a trust takes title, not individuals. So it'll be very interesting to see how many parents are involved in that. Now, it is absolutely true that parents can give their kid money to invest in residential real estate. No question about it. So it may come out. But notice this last bullet point. This includes earnest money deposits held by an escrow agent, which might be your brokerage, which might be somebody that has agreed to serve as your escrow agent on all your deals, to the closing agent. So how many escrow agents understand that they are going to have to tell the closing agent their account number? So this is going to trigger some questions. All right. Let's circle back to something that John said earlier. You may, of course.
So I also want to kind of open up a different segue as to our office has made a decision that we are going to hire a third-party vendor to perform these services for us, okay? Is Cole still in the room somewhere? Oh,
Same.
You're in. So Cole over at Salter Fiber is also going to do the same. I don't know what other title agents intend to do. But the education, if you're closing my office or if we're holding a deposit, is going to be, in this instance, you're going to be contacted by this third-party company that's going to gather all of this information. So that's just a business decision that my firm has made. It sounds like Salter Fiber's done the same. Patty, I don't know if you've made a decision yet or not, but essentially, when we hear closing agent, we'll be calling, more specifically, third-party vendor. You're going to be calling, emailing, providing that secure portal, providing all that extra layers of stuff. So that's an education point for you when you're engaging with your customer also. Sorry to interrupt.
No, not a problem.
So if I can just add that, there's possibly two ways to, so like your closing software, or in our case, we use Qualio, which is the portal both between the realtors and the customers of the parties. So we might be collecting the information through that portal. And then different companies, different lawyers are going to be using other third parties to submit the report, while some of us may report ourselves through FinCen. So you might see multiple different ways of collecting the data as well as who's actually going to report the data.
Yeah.
Just
And this is all brand new. It'll be really interesting to see how effective hiring a third-party vendor to do this for you really works. Because it's all brand, and these vendors have never done, well, they claim to have done something similar to this in other transactions, but it'll be very interesting to see how all this works. And, you know, one of the key messages is, if nothing else, closing agents, title agents, and you have one common goal, and that is to close the transaction, but also to have buyers and sellers walk away very satisfied with the way things were handled, with the efficiency and the professionalism with which that transaction was handled. So we have got to work together to make sure that buyers and sellers understand the challenge of these types of transactions. I want to go back to something that John mentioned about the unwilling buyer or seller. Again, the seller doesn't have to provide that much more information than they would normally have to provide, because they have to provide their social security number anyway for a transaction, and their address, et cetera, et cetera. But that unwilling buyer, how are we going to deal with that? And there is nothing currently in our standard real estate contracts that talks about this new rule because it's brand new. But your FAR Bar Contract Committee has been very hard at work coming up with a revision to the FAR Bar contract that will address all of these things that we've been talking about today. And Patty is on that. Well, technically not as of today. You're on the subcommittee. So here is the new provision that will soon, we hope, soon be going into the FAR Bar contract. And note that it says, you know, it requires certain residential real estate transactions, blah, 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 be reported beginning March 1st. If this transaction requires completion of a FinCen report, seller and buyer shall, no later than the day prior to closing, provide the closing information agent with the required information no later than the day prior to closing. Now, it talks about a summary of the kinds of information that the closing agent is going to ask for. And importantly, down here, it says the buyer is going to pay the fee charged by the closing agent to comply with this law. There will be a fee. This is above and beyond what closing agents have traditionally dealt with, and complying with this rule is not going to apply to every transaction that they handle. It's only residential transactions in which an entity or a trust is a buyer. Now, the concept of delaying the closing is a very interesting one, because you notice in here, it doesn't say closing agent has the right to delay the closing until all the information is collected. Why not? Well, is the closing agent a party to the contract? No, it's the buyer and the seller. So we have to put the obligation on the buyer and the seller to comply with the requirements of the rule, so that theoretically, let's say that you've got a closing date of March 10th, and the buyer has not provided the closing agent with the necessary information the day prior to closing, and the closing agent says, hey, I'm not closing until I have it, the buyer is in breach. And the seller can complain when that closing is delayed. But there is no way to give John and Patty the right in the contract to delay the closing, because they're not a party to it. Comments?
So, we struggled very hard with this at the committee level, and just so you know, when the bar committee comes up with language and it has to go to the bar to be approved, which it was, and then also to Florida Realtors leadership. So where it's gonna be is, you know, where you had the GTO language before. So the GTO language is coming out and the new FinCen language will be there. It is absolutely in production, but I can also promise you that it will literally be maybe the day before or March 1st, where it will actually show up in your app files or Form Simplicity or whatever you use. Because until that date, we don't know if it's gonna get postponed again. Don't think it will, but that's the reason that they're doing that. So like Melissa said, the buyer has the obligation because they're the ones taking title as an entity. And so we worked very hard through that, a number of different renditions, but that's what we ended up with. And just from a closing agent perspective, we don't really want it to stay prior, but we had to do it that way. But just know that that's not what we want. We need it as soon as possible so that we can know, you know, if it's gonna close or not. I've also been told by a couple of our underwriters that they're actually gonna make it a condition of the commitment. So if that in fact happens, I guess then you have a title issue so I don't know how that's gonna work out. So then it might kick back to being a title issue. Yes,
Do you have any idea what the cost is going to be that is going to be passed on to the buyer?
I think every closing agent, title attorney,
It's going to be a range, because if you have an LLC that has multiple layers of LLCs, and you've got to dig down and get to where the flesh and blood beneficial owners are, it's going to be more work for the closing agent to collect that information than it would be if, you know, it's a single member LLC, and it's really easy and if there are 4 members of the LLC, each owning 25%, and they're not here locally and they're spread around, or they're on a month-long trip to Europe, and it's just a lot of trouble for the closing agent to gather the information, or you have a somewhat unwilling buyer, it's gonna affect the fee. We don't want to talk about standard fees here because they're not gonna be standard. But
Oh,
it's
it's
gonna
gonna
be a range. It's gonna be a range. And I don't know, thankfully, I don't have to worry about that. But I'll sympathize with Patty and John all day long.
So being sensitive to any antitrust,
Yeah.
we're not doing any price fixing, okay?
Yeah, we're not doing that.
Most closing agents would say, if you're using a third-party service provider, cost of that plus something. And
I would
keep in
agree.
mind, the stock and trade of a lawyer's time, lawyer's time is time, okay? So if I get someone that is just belly aching and they're not gonna do this and do that, and they're running my staff around in circles, that cost plus may be very different from someone who we're going to send out on day one. The communication, here's the platform, this is the information you can provide. 3 or 4 days later, we've got that back. Awesome. Okay, well, shouldn't that cost plus be adjusted in a downward direction because of the compliance? Okay, but I want to emphasize again with Patty, the day before closing, please, guys, this is education up front. You know, before you sign the contract, you gotta know if you're buying an entity or a trust, and you're paying cash, you are going to be requested to fill out 111 fields of information. This isn't something where we attach a PDF of an escrow deposit and email to. Whole different animal, okay? So the more education up front, the more, hey, get on this right away. That's gonna increase comfort level.
I'm trying to look at it from a practical standpoint. So we have our buyer go, fill out the form completely, but then it doesn't close. Are they out that money?
I would assume under the underwriter that I've talked to, Cole, let me know if you think if the transaction does not close, they will give the fee back.
I
Okay?
mean, the third party.
The third-party vendor.
I'm sorry, the third party vendor will give that money back, okay? I don't know that all of them are going to behave like that, but the ones we're talking to have. All right, I see 3 questions.
Yeah, Cindy, Kathleen, and Sam.
The third party vendor, are they attorneys?
They are major title insurance underwriters.
They,
No,
I mean, some of the determination who the power of fees into trust is in that legal work that an attorney needs to figure out.
I don't know exactly what their determination is going to be, but they would be, as part of their business, they spin off title examination and creating the requirements for the title insurance commitment. What level they are going to get into in terms of merely gathering information versus providing analysis is unclear to me yet.
So how often do you go to closing and the day before closing, you get word that they want to close not in their personal name, but in an LLC they created last
Good
night?
question.
Well, check that box that says the buyer may not have signed this contract. So that if they come in, like many people do, and go, oh, by the way, I want to add my uncle and my sister and all that to the deed, and we're like, we're at closing, we have loan documents. No.
Well, what's to prevent someone for closing in their name, John Doe, and the day after getting a title company to transfer it
They
to
gotta
their
report.
LLC?
Nothing, but it's covered. It has to be reported
Yeah, it had to be reported.
because there's no dollar threshold. So they convey from their individual name to an LLC for $0. It's reportable. It has to be reported.
Okay, thank you.
Is that the same for trust though?
My answer is no, Cole. The question was, is that the same for trust? Because if I'm doing from John and Mandy Roscoe, husband and wife, to the Roscoe Revocable Trust for no consideration, I do not deem that to be a reportable transaction.
He is correct. So as long as it's that type of trust conveyance from an individual to a trust of which they are the grantor settlor, then it is exempt. So they can take title individually in a day, a week, a month later, transfer to their trust. If it's under those circumstances, it's exempt. But a sale from an individual to an existing trust that they are not the grantor settlor of, that is not exempt. So not every transfer to a trust is going to be exempt.
I just want to comment back, Kathleen, if, many of these third-party vendors are in fact through underwriters, but there are some third-party vendors that are not through the actual underwriters. They're actually just third parties. So, there's a lot of different ways of our industry attempting to securely collect and transmit the data. So it may not always be through an underwriter. All right, okay, so the other thing was, this is through, American Electric. Says transfer to LLC or trust post closing. If an individual purchases in their individual name and then transfers to an LLC or trust for zero consideration, is the transaction reportable? The answer is yes, other than for estate planning purposes. So if they're just doing it to avoid reporting, it has to be reported. So hold on, I saw Cindy and then I saw Susan back there. Cole, did you have something you needed? Yeah, I got Sam too.
Well, and that's the question, if the realtor knows that this transaction is not reportable into husband and wife, and they're going to do a deed the next day, the estate planning attorney into the trust, is there any guidance on whether just sharing the facts of the law is something that the federal government's going to be okay with?
I'm not answering that one.
All right. So tell me your question.
Sure, you're doing your buyer rep and, husband and wife have a revocable trust. And they say, well, we may take it in husband and wife, and they take it in a revocable trust, we're not sure what title's gonna be. And the realtor says, well, if you take it in the trust, it's just cash, it's resi, we're going to report. And if you just leave it husband and wife, you don't have to report, it's not a requirement. And then husband and wife say, okay, we'll just have our estate planning attorney put it in the trust right after closing, that won't be reported. And the realtor says, that's the law.
Well, I would back up, and as a realtor, I would not say if you do it this way, it's reportable. If you do it that way, it's not. That was mistake number one.
Giving legal advice.
Yeah, we don't wanna do that.
That is, a realtor should not be given, that is legal advice. They should not be doing that. So they shouldn't even be put in that position. So I think they've already made the mistake.
And so for these two up here, same question.
Well, I think as a title agent, I would say you need to talk to your lawyer.
At least John.
I think so.
I'll be the buyer's lawyer.
Right.
So in this particular instance, if you're talking about a gratuitous transfer from a husband and wife to their revocable trust merely for estate planning, that transaction is not reportable. I think the one that is gonna be cute, where we're gonna see people trying to avoid it is, okay, I'm XYZ Builder LLC. But I'm just gonna close in John Roscoe on the 1st of March, and then on the 2nd of March, I'm gonna transfer it to Roscoe ABC Builder LLC. Is that reportable? The answer there is yes, that one is reportable. So if you find yourself in that situation, do refer to legal counsel, or alternatively, if someone's gonna prepare their own deed, make sure you go to the top left-hand corner where it says prepared by and returned to John Roscoe, wipe all that out.
Okay, wait, you gotta get, hang on, we'll get you. Cindy.
I have two quick questions. John, you said that the third party vendor fee would be given back. Is that through the underwriters? Like, is it collected up front like an appraisal fee for a lender?
My understanding, Cindy, is that the third party vendor will give the buyer an option. You pay me X fee right now up front, or alternatively, we'll collect it on the closing statement for $100 more. So the encouragement when we get a rhythm of this is gonna be, hey, listen, you're gonna be contacted by XYZ title underwriter for the purpose of gathering the information for these 111 fields. You're gonna have an option of paying up front, and if the transaction cancels, you get your money back. Or just wait until Patty and John or whoever else is closing the deal, we'll collect it on the closing statement, but there will be a surcharge for that.
I'm just concerned about the seller getting stuck with that fee if the buyer walks, so.
Correct. Contractually, it is on the buyer. In practical world where there's no such thing as a contract with a son of a, you know what? I too am concerned, but that's why I like that direct privity between underwriter and buyer. That keeps you, me, everybody out of the picture.
And then the other question is, if the buyer doesn't comply, there's no language in here that says that they're in default and the seller gets their escrow if they're beyond like their.
If there's a shall, that word shall, if they don't do it, they're in default.
Oh, what did I do? Oh, thank God.
So it says they shall.
Doesn't say that they get the escrow deposits.
Well, you go to the breach
You go to the
provisions.
breach, yeah.
You go to the breach provisions in the
Yeah,
contract.
but Cindy, I mean, I can envision the letter right now on my letterhead. Seller has performed all of their obligations under the contract. They are ready, willing, and able to close. You, as the buyer, contractually obligated to provide the information to comply with FinCen and have failed to do so. You are in breach. We are claiming your deposit. How'd that sound?
I have Susan back there and then back here.
Yeah, I have two questions from online. One is a question for clarification, but mentioning it would be a buyer obligation and breach. If the underwriter made it a title defect or a title issue, would that create an issue for the seller?
I didn't really understand the question.
Let me,
Question.
let me weigh in on the title side because I'll be honest with you, there's a few things that we don't know. We know that there is going to be a Schedule B1 title insurance requirement to comply with FinCen. Okay? I'm having a hard time making the intellectual insurability leap that failure to comply with FinCen makes the title uninsurable.
Right, me too.
Okay, I'm having a hard time making that leap. The practical answer to the question is, if the buyer doesn't provide this stuff and its closing date of March 1st, and they're just refusing to comply, and either we're now claiming a default or claiming a deposit, the practical damage is, yes, the seller's gonna be harmed. They got a closing this afternoon that they need the proceeds from this sale to go buy, or the one that's in California. So from a practical standpoint, yes, I think the seller could be damaged by the buyer's failure to comply.
I think that these issues that, you know, like Melissa said, this is also new, but I think those type of issues, the FAR Bar Committee will continue to work on, and I don't doubt this language will get changed and tweaked as we go through the process.
And then there was another question.
One more question, and I think the answer is, does it make a difference whether the LLC is single member or multi-member?
No. If it's a single member, that single member is the beneficial owner and they have to provide their information.
My question was just more to the fact that we have a lot of parents and children in trusts. So how, so you're talking about husband and wife, but let's say it's mom, dad, son. So is that gonna fall into that same situation, or is it gonna be the opposite where they can't transfer because there's a third person involved?
No, it's not who the beneficiaries of the trust are if you want it to be an exempt transaction.
Let's say mom and dad have the money, but son's gonna live in the house, and they create a trust. Mom, dad, son on the trust. Right?
But who are the grantor settlors of that trust? The mom and dad? If it's the mom and dad and the son just happens to be a third beneficiary, it's not who the beneficiaries are. It's who the grantor settlors of the trust are.
Most of the time, I've seen them, I've had them done where mom and dad have it until they are gone, and then the son is the beneficiary at the end of their life, right? So do we have any, is that?
That would I'm gonna go out on a limb here because I ain't practicing law anymore. And the other thing is, we don't know exactly what the answer is, but if the mom and dad are the grantor settlors of the trust, that would be exempt. It doesn't matter who
Their
the
money and their granting.
you're not letting me finish. The future beneficiaries of the trust are not relevant.
Okay,
That is not relevant.
okay.
And I will add to that same beneficiary, the long-term beneficiary after the parents are gone, if he says, I demand that you convey this house.
Yeah.
The trustees, being the parents, are gonna go, we did this for a reason.
Yeah.
Little snot-nosed punk. No, we're not doing that.
I'm gonna say go talk to a lawyer, obviously, but that's come up a ton of times in how people wanna buy stuff. Now, that's gonna be a way easier. Mom and dad's buying the house, just buy it in your name, don't worry about it.
Well, you're also touching on, you know, something that's semi-unique to our community
Yeah.
insofar as we have a lot of kitty condos.
Yeah.
Yeah, we've got the University of Florida, Santa Fe College, and parents are wanting to be smart and they go online, get all educated on www.assetprotection.com. And they're gonna form an
hadn't heard about
LLC and protect them from the drunkard's liability with the house and all that. Okay. Well, those are all great things, but the consequence of that is 111 fields of reporting and a fee paid to an underwriter
Right.
for the privilege of holding title in your LLC that you pay cash.
Right, right.
Monto, you have been waiting very, very patiently.
Sam too.
Same.
Two quick things. First one, because we all know fires are gonna get smart or if there's people now. So my quick question is, let's say you have it in your own good name and you go down a week or two after closing. Let's say we have to close again, you don't know that is their intent. Is that now in the clerk's office to do all the reporting? Because they're gonna go directly to the clerk's office. I put this in my LLC.
I believe the hierarchy is on the person that prepared the deed. So now you're outside of your closing and title office, outside of my closing and title office. If someone chooses to do it on their own, they step into the shoes of reporting the transaction, not us.
As long as I have no knowledge.
Yeah, it's not, we have to know.
And so the other question, we all know, we probably all already have contracts that are subject to this, and this language is not in there. Is there any kind of addendum that's gonna?
Right. So I was gonna make the point that this law applies to closings that happen March 1st and after. So existing contracts that don't have this language in there that are scheduled to close or end up closing March 1st and after, the rule is going to apply. So you're gonna have to work with the closing agent and the buyer and the seller to get this done.
So is there an addendum already, maybe
I don't-
from this that's?
There's no addendum.
Now, all I've done is, because I had the language, so I had the language, but there's really nothing you can do but negotiate.
So then we need to have that language now to these closings then.
If we're under contract now,
Ask your brother.
If you're under contract now, but not closing until March 1st or after, the rule applies. So if you're under contract now and you think that your transaction is covered, get in touch with the closing agent and it would be great to get an addendum to the contract signed.
And even without an addendum, it's still federal law.
Yeah.
You might argue who's paying.
True. Sam,
Is the data gonna be stored anywhere for repeat buyers?
that's a
No.
very good question.
It is not,
No.
it is not. And so for repeat buyers, you gotta fill it out every single time. FinCen would not consider that.
And pay a fee every.
And
Yes.
potentially, yeah.
I mean, Sam, how about this? Okay, you got an investor that's an LLC that's paying cash. They give me a $2,000 deposit, which then has to be verified. Let's just call it for discussion purposes, example, $500. And then we close and they have to go through the same exercise again for another 500. $2,000 deposit, $1,000 in fees. That's not gonna feel real good. But I think that's one of the practical realities that is going to be confronted.
But even the rule specifically states we have to collect it
Every single time.
every single time.
You have to collect the information and report it every single time.
You got a question?
Not from, an individual to a trust. About this individual purchasing an LLC. I want to transfer to the trust.
They purchase in the name of an LLC. You're gonna have to comply.
Yeah, exactly.
And then the LLC conveys to a trust.
Yes.
Would that second transaction be exempt?
Zero money. but
Yeah, I would say it is still covered.
it's still covered.
Yeah. I wanted to make the point that it covers contracts in existence now. We've already covered most of these traps. Last minute buyer change of entity, hard money lenders not exempt, seller financing not exempt, and remember, no dollar threshold. So don't assume that your tiny little deal that you're handling for a friend and charging them a, 0.5% commission, that is still covered.
Melissa Leslie had a question.
So some of our buyers use their IRA money to purchase property. Is that going to fall under the reporting?
Yeah, cash, that's still cash.
So it just depends on how they're taking title.
Correct. I mean, they have to take title in an entity,
Right, but
or,
if it's an end of, yeah.
yeah, but if it's individual, it's
No,
exempt.
but it's always in their IRA names.
But if they're paying themselves back,
Doesn't matter.
Ben, did you have a question?
Yes, my question about this day, March first, well, not for the real estate council, but for people who already purchased their house in their individual name and plan to transfer to the trust or entity name after first of March. Is this new law still require those people who have to report?
If it is a trust that is not of the type that is exempt, yes, they will have to, whoever prepares that deed for them will have to report.
That's involves. Yeah, it was in the past, in the future.
Yeah,
Once they do this switch.
it will be reportable after March 1st.
Yeah, I got Susan back there, but
Okay, is there information collected for this report that is not collected by a lender if they were to get a mortgage?
Say that again?
Is there information collected for this report that is not collected by a lender if they were to get a mortgage?
I don't know.
beneficiary.
Yeah, I don't know what lenders typically collect.
I would assume the entire seller side is new.
So I think that, I don't know, I haven't applied for.
Well, that's true.
a loan in a hot minute, but I don't know that you're gonna have beneficial owners for a residential purchase disclosed in a loan application. In a commercial setting, you will, you're gonna sign a beneficial ownership report listing everybody, but we're focused on the residential for today.
But if an LLC is the buyer and a bank is loaning the money to the LLC, they're going to want to know who the beneficial owners of the LLC are, aren't they?
Don't know the answer.
I don't know the answer either.
Been a minute, I didn't borrow the name, but LLC, so.
Yeah, I understand.
And they,
Yeah, they may ask. And it is true. Cole made the point that there is more information required by a seller. And I guess it's an irony that if there is a bank loan and the bank doesn't collect any information from the seller at all in connection with the transaction, it is still exempt because the law focuses on the buyer.
You mentioned about home equity loans. So let's just say, I believe you said that they were not exempt. If they got home
If it was on
equity-
another property, not so much a home equity, but if you were getting money from another asset, another property and buying, then that becomes cash.
So Jesse, teeing that out a little bit further, you and your husband get a home equity line of credit on your principal residence to pay cash for Chesapeake's rental LLC for your kid to go to college or for investment purposes, you're reported.
Right.
So what about it was Chesapeake Rental LLC that got the home equity loan and then Chesapeake Rental LLC used that money to purchase another asset?
I think the analysis is still the same.
Because to you, it's cash, and I guess on the contract, it's cash, unless depending on how.
Right.
And to FinCen, it's cash.
It's cash.
Yeah. And all the banks have a whole department for this, just so y'all know, there's a whole department for the bank papers in it. So every financial institution does it the way on it.
Susan in the
If
back.
a homeowner buys in their personal name and then after closing transfers to their LLC via quitclaim deed, sounds like they need to report. Where are they getting that information that needs to report if they don't have an agent or someone else mentioning this new process? And is the county recording offices going to stop the recordings?
County recording offices should not stop the recording, and God forbid they do, but they shouldn't. They shouldn't. And one of the aspects of the law that we didn't go into is the cascade of people that are obligated to report these transactions. First in line, closing agents, but then anybody that prepared the deed. So if they went to a lawyer to prepare that deed to convey to their LLC, that lawyer is obligated to report. Now, if they prepare their own deed and record it, transferring ownership to their LLC, that probably is not going to get reported, and they probably aren't obligated to report that, which is weird, but that's what Alta says. That's what experts say. That if you prepare your own deed and record your own deed conveying to your own LLC, it's not reportable.
And the defective deed comes back and it's labeled.
Correct. Then you got to deal with the defective deed when they try to sell their property. Yeah.
So what happens once this transaction is closed and reporting has been sent off to the government? Then if they find something, what goes on from there? Was that really just an matters to us?
Well, if they suspect, I guess, if law enforcement identifies that LLC, those beneficial owners as dicey people, they will just start an investigation. And yes, it is true that if they decide, and I'm guessing here, they decide that that particular transaction money was laundered, they'll probably inquire of the people involved in that transaction what they knew about the transaction. Lesson: don't deal with dicey people. It's all dicey. Yeah. Mary Beth.
How do the third parties, it sounds like this could be a real issue with information like that. So how secure the third parties?
Well, that's why we're saying use the portals, no emails, no texts. Use these secure portals because there's insurance backing them.
But I'm saying, how are closing agents choosing a secure portal?
We are choosing them based upon what we feel is the very best to secure the information, because we're going to be responsible if that information gets out. So I can assure you, we're vetting them pretty strongly. And some of them are through underwriters, some of them are third parties, and some of us are going to do it ourselves.
Understand that if Patty and John hire a third party to collect and report the information, they are still responsible under the law. They are still on the hook for complying with the law.
Yeah.
The third party vendor is a convenience, and efficiency factor. But they are still responsible. They cannot absolve themselves of responsibility by hiring the third party. So they are vetting them very heavily.
Helen.
As I'm trying to think about how to educate my buyers into this area, I thought about having an envelope of some kind and giving it to them and say, just like we do with sellers, say, start collecting the materials and get them together, put it in a cabinet and get them. But for these type of materials, most of it's gonna be online. So then I'm thinking, you guys don't want them to deliver a folder, hard copies of this information, right? I can tell them, know where your stuff is, so that when you get the closing agent's email saying, this is your portal, you're ready to send it in.
Well,
How else would you?
yeah, I think if somebody, we've got people out there that just don't know how to use portals or whatever.
Right, that's why I
So,
was looking at hard copy.
no, I'm just talking for myself, and I'll let John talk for him, but I would accept it. And then I'm going to make sure that it gets shredded or properly discarded after I put the information into the
Yeah.
report. But we're gonna have people clearly that aren't going to do that, but I'd rather have you deliver it to my office. When I say my office, the title office, not my real estate office, deliver it to me and I'll enter it.
So if I.
But I definitely don't want it or
What
text.
you're gonna need, put it in this folder and take it to the title agent and take in your escrow check.
I would be okay with that.
Don't allow you to do that.
I think we've also got to, kind of double down on what is your role in this, right? Okay? Because you are not, Helen, going to be the collector of the
No,
data.
I could have a folder to do that.
And bring to us.
That's right, okay? Just like you guys do not participate in, oh, here's your wire instructions. No, we don't do that anymore either, right? So your job is to facilitate the flow of information. Hey, listen, There's a new federal law, FinCen, if you're buying cash in a trust or an entity, you're gonna have 111 fields of reporting. The closing attorney can assist you in getting to where either the third party vendor or the title agent themselves may be collecting that data. Please get in touch with them right away because it's gonna be burdensome to collect this data and facilitate it. Well, can't I just email you the stuff? No, don't email me the stuff. There's processes and procedures. So again, I always go back to what is your role in this? Your role is to facilitate the flow of information as to where the information is supposed to go.
I'm gonna encourage them to do it in their inspection period.
Absolutely.
That would be wonderful.
Great.
We got-
Shane.
go ahead.
And what she said, piggybacks on what I was gonna ask you, John. If I'm the listing agent and I see a problem with this last day thing, that where it could come in. It can, as a GACAR attorney, can you guys let us have an addendum addition or something in 19 and 20 that says that it has to be done within the inspection period, or has to be done 15 days before closing or 10 days before closing?
That's a very good forms committee question. We're not in session on that yet, but we know.
Yeah, it might be a brokerage level decision, but we could certainly, we could look at it at the GACAR forms level. It will not happen from Florida Realtors or the Farm Bar Committee, but we could look at it locally.
I mean, what you're essentially talking about there is, if the buyer fails to comply with FinCen reporting, then it's seller's option, they may terminate the contract and receive the deposit.
Yeah.
I don't know that that's gonna get a whole lot of traction, but I think that's the sentence, right?
But the urgency
But
there.
But the opposite side is that a lot of sellers are not gonna be willing to take it in the name of the trust or in the name of the.
Certainly a consideration
Yeah,
for
it's
sure.
a huge consideration, so.
Well, we hope,
Yeah.
some more
I just
questions.
want to confirm, you did say that when they get a deposit, you have to ask all this information, and then when the closing happens, you're doing the same thing?
Right, no, the closing agent's going to have to verify where the earnest money deposit came from in the bank account when it gets transferred to the
Or
closing
not the
agent.
rest of, not. So when they make a deposit, they're not gonna have to do these,
No, it's when you send that money to the closing agent.
okay, because we have
Yeah.
so many from other locations that I don't prefer my buyer to have deposits in those random places, so.
Ellen,
But essentially, I think the answer is, yeah, you gotta do it twice.
Well, that's what I'm saying, so if I have a local, I give it to, the deposit going to you, but the closing office is South Florida. You're gonna have to go through that. Go for the deposit and not have them answer all those questions,
There's two
and then
different
they'll have to do that
verifications.
again.
Two different verifications. You as the realtor have to verify that the deposit got to the escrow agent.
Right, but that's what I'm saying, it's like if we're
But
to
you're
get,
not gonna do the second phase of it. When the escrow agent sends it to the closing agent, that's when the closing agent's going to have to find out where that money came from in the bank account.
so as the escrow deposit, if like if we give it to our local, one of you.
It's just
escrow-
them, they're going to have to give it to the closing agent.
You won't have to.
You're not gonna be
that for
involved in that.
Okay.
But do we have a common understanding that if I receive a $5,000 deposit from XYZ LLC, I've got to verify that information?
But that's what I'm saying.
Or you-
No, you're not verifying it when you first get it, you're only verifying it.
When you send it to the closing agent.
If you're the escrow agent and the closing agent, then you're reporting it, but if you're only the escrow agent.
Once or twice.
Well, that's why
I'm confused about the question.
so, okay, so there's a lot of South Florida listing agents up here now. When I have a buyer, I personally do not send their escrow down to South Florida because I don't know Joe Schmo and stuff like that. I rather have them hold their money for inspections and escrow here
With
I
who?
with our title company or escrow
Okay.
person here.
So when the
So-
buyer makes their initial deposit to an escrow agent
Yes.
that may not be the closing agent,
Correct.
that does not get reported to FinCen.
Okay, so they're not gonna do, because you talked about having to do it.
When that escrow
Okay,
agent
so that's what.
sends the money to the closing agent, that will be reported to
Okay, that's
FinCen.
because we said twice on fees, so I got confused.
If John was doing both, or if I was doing both, but I'm still only reporting the FinCen report once.
Right.
I'm reporting back to you that I've received it.
Right.
Just like we've always done to comply
But
reports.
you're not gonna charge them twice more.
No,
No,
That's where I was getting,
No.
no. It's only getting reported to FinCen.
Okay, cool.
Yes.
Same time, I often receive that my representing buyers, escrow comes in, it gets, into the Berkshire Hathaway account. And then when it's time to disperse closings, they take it out of, that, it never goes from Berkshire Hathaway to the closing agent. They come back out. So should I start requiring that those checks go directly to the closing agent instead of sitting with my broker?
So you're just saying like a net check situation.
Say that again?
It's
No.
a net check situation. So they're just net checking your commission.
Yeah,
So it's never going to the closing.
right. So is that my broker?
So the closing agent's never collecting the buyer's funds.
right.
Well, we do that a lot, don't we?
Yes, but then the closing agent's never collecting those buyer's funds, the
Correct.
way I see it.
That is correct.
Is it my broker's responsibility to vet that check?
No, I think you can continue to net check.
Here's
Sam.
like I'm looking.
I'm just making sure that I understand your question. If you're just netting the E&D out of the check that the closing agent cuts you for your commission, and you have never sent the escrow money deposit to the closing agent, that doesn't get reported to FinCen.
Okay. Even if it was written, does it matter if it was written by an individual or?
No. No,
Okay. So that's one way that they could save the double service of having to pay to go through FinCen.
it doesn't matter. I mean, the closing agent is going to report to FinCen, and the fact that they either got the earnest money deposit from a third party or not isn't going to double the number of reports they send to FinCen.
Okay, because I thought you said that when they make their escrow deposit to a title agency, it has to go through that process, which is going to require.
That is what I said, and I think I may be wrong.
Yeah,
No.
Damn.
just remember there's an escrow agent, and a closing agent, they aren't always the same.
Okay,
This is great training, thank you.
I may have been out when you guys brought this up. What about contract flippers? Who's the seller?
The what?
Contract flippers.
Like wholesalers?
Also.
Yeah.
Home delivery.
Who's the seller in that case?
Well, the seller in that case
Is
is
the
going to be
homeowner.
the original homeowner that's the party to the contract.
How many of those have you run into where they don't even know they're selling their house to a different person?
Right.
Right. But if that wholesaler.
Oh,
buyer-
likewise, but
that wholesaler buyer is paying cash and purchasing in an entity.
well,
Or
they never have plans to actually buy the house.
correct,
Yes,
but
yeah.
let's leapfrog
Okay.
to the next person. They're buying in an entity, paying cash.
Sure.
The
They're
wholesaler
signing.
sweeping their fee, then send reporting on the buyer.
So who's getting in touch with the original owner?
Well, presumably the title agent, because
They're the seller.
title never transferred into your, what I call officious intermeddler.
You ever run into one of these that doesn't have an email or a phone number?
Not necessarily, I see your point. Yeah, I see your point.
The seller's actually assigning that contract,
Correct.
so they're still,
Seller doesn't know
they're
that,
still the seller.
Yeah, they're still the seller.
Yeah, but the seller doesn't know that. That's kind of, I'm hoping we can phase this out of our industry.
Yeah.
Amen.
This has been great, y'all have been
Good job.
wonderful. Very-
Yeah. Thank you all.
Thank you, Melissa.